It's working.
All right, we are officially live. Sorry for the technical issues this morning, you guys. Zoom decided to lock me out on my computer, and even though it said it resent a code, it has not. And so I couldn't actually log in to my account the normal way. So I'm on my phone. Luckily, my phone did not lock me out. So if you're here with me, and I apologize because I have to scroll on my phone to see everybody, but just pop into the chat, say hi, let me know if you've got a question today, and we'll try to get them handled. Sorry for the weird lighting. Let me see if I can tone this down a little bit. And welcome to another Monday. How is everybody doing? And who has questions today that I can help you with? Raise a hand or just pop it into the chat, because I do see the chat come up across the phone, and we can start a discussion. And welcome to Nolan. All right, questions about trust. Okay, here we go. Okay, let's see. Yasmin, okay, let's start with Yasmin's. Do I need to trademark my new podcast? That's a great question. So, and Yasmin, are you launched or are you thinking about launching? Like, are you already launched or are you preparing for launch? What I want to know is, like, is your title of your podcast already out there live, or are you working, you just launched your intro episode? Okay, well, congrats. What is the name of it? And if you want to just keep it in the chat, that's fine. If you want to go live, you're welcome to join me. The hero frequency. Okay. So this is something that I will do for folks that show up live on these calls. Let me just go pop over, and I'm going to look up at the USPTO for you, the hero frequency, and let's take a look and see if anything shows up. So let's talk about why you would want to trademark it versus why you may not, right? So the first question I ask anybody in regards to, like, whether or not you're at the point of really saying yes is, would you be devastated if somebody else took that title and used it for their podcast or in their business, right? And let me just run a quick search. And so if the answer is yes to that, then I recommend that people look pretty seriously at getting a trademark registration initiated, because that usually means you have attachment enough to the word or phrase. If you're feeling possessive over it, then it may be time to look at that. If you're like, I'm not, it's fine, I'm not really attached, you just wonder if, like, it's something that you have to do. No, you don't have to do it. And I'm just going to pull up the chat again.
So can you hear me?
I can. Yeah.
I figured it might be easier than having you toggle to read the.
Right. I know. Me on the phone and trying to find the chat. Right. Yes.
So is that so with podcasts, it's different from if we have something that is something we have written that's online, right? So from my understanding, for example, if we wrote something online, that's kind of automatically copyrighted, even if we don't specifically do anything extra.
Yeah, this is a great question.
So
great question.
So with the podcast, it sounds like that's different, where you really have to go through the legal route to make sure that belongs to you. Because if you're using it first, but someone else comes and uses it later, but then they go and get trademarked before you, that becomes theirs. It's different in that way. Yes.
Yeah. So what you're talking about is copyright versus trademark, right? So my quick overview of the relationship really between copyright and trademark and what portion of your business they protect. People who've been on the call probably have heard this before, but think of your brand or your business like a mountain, right? The top of the mountain, which is the part that's visible from the marketplace. So the snow-capped peaks, right? That is what is protectable by trademark. This is your business name, a signature course or program name, a tagline, a logo, in the case of a podcast, the title of the podcast, right? So that is protectable by trademark, a word, short phrase, or logo. The body of your work, right? So the other ways that you publish information, maybe you write articles, you Many of us create video tutorials, courses, workbooks, worksheets, all kinds of additional assets in our business that we use to instruct, guide, share information, provide via downloads, etc. Sometimes, obviously, paid products and courses. Those are protectable by copyright. And what you're talking about, like when you create something, when something takes tangible form, an idea takes tangible form, whether it's an infographic, an article, a photograph, like let's say you're in the art world, as soon as you've created it, you're right that copyright rests with the creator. You don't have to do anything to like claim copyright. You don't even by law have to put a copyright notice on your stuff. Although if you've been through any of my previous trainings, you know why I recommend that people do put copyright notice on their material. And it's still because people in the online space, there are still plenty of folks that feel like they just get to take what they want, right? They like something, they screenshot it, they take it. So copyright notice at least will put some people on pause. Now, the difference though between having copyright in something that you've created and having a federally protected copyright, like one that you've registered, a copyright registration with the federal government, there is a big difference because you cannot enforce your rights. Let's say somebody actually infringes your copyright. You cannot sue them, recover damages, do any of that without a federal registration. So the federal registration is what actually allows you to enforce your rights, including, and the thing that usually makes suits like that problematic are that they're cost prohibitive. People can't afford to bring them. So if you have a federal level registration, you also can recover attorney's fees. So that's a tremendous benefit. And the reality is, because most people that I serve, they create a ton of content. They're constantly producing audio files, video files, written work. Like, the majority of them are major content creators. Do you need to copyright everything, right? Do you need to get federal registrations for everything? The answer is no. But you do need to understand what is the core body of your work, what is the core assets that you create, your core teaching points. Anybody who's been in their business long enough starts to, and let's admit John Joyce. Welcome to John. Anybody who's been in their business long enough starts to recognize their patterns, the information that they present over and over and over, the way that they package it in different ways. And the question that I have people ask is, what is the most powerful presentation of that information? Is it in a video? Is it in an audio file? Is it in a written format? Is it, some other way? And seek protection of that so that you have the concepts protected. You have the way that you express that particular idea protected, right? But you don't have to protect everything. Now, copyright registrations are relatively inexpensive. Let's pretend you have even a course. Let's say you have 10 videos within a course, or, and accompanying that are some written pages or a workbook or something. A copyright registration for a single registration is like $45 to $60, depending on what it is. You could have $450, $500, $600 worth of registrations and protect a chunk of items that really represent the core of your work. So it is about selectively choosing what are those best representations and making sure that you protect those first. And then also keep in mind that, because some people are like, okay, well, I've been doing this for 10 years or 15 years or even 5 years. I know what I create. I know what my message is. I know, even maybe the core assets that I need to look at, but I created them 5 years ago, right? So with copyright, you have to seek for something to be protected and to take full advantage of the benefits of a copyright registration. You have to seek protection within 3 months of creation, So there
Wow.
is a time frame attached to it. And what it means is that if you've already created assets that you that you feel like really represent the core of your work, maybe it's time to update those or do a refresher or change the way that they're packaged. Do something so that you have a new reason, like it's substantially updated enough that you could seek copyright protection over it within that 3-month window.
I see. That
Right?
makes sense.
Yeah, so that's a bit about copyright. Now with trademarks, right? So again, we're talking words, phrases, logos, right? These are the things that are at the top of your brand, signature course or program names, podcast titles, the name of your business, etc. Trademark registrations, they're a little bit more expensive. They're not outrageous. My starting price on a single class registration is $14.97, right? $1,497. While that's an investment, it should not be cost prohibitive even to a small business if it's an asset that you really care about, because again, it is the piece that is visible from the marketplace. Trademarks are super important because it does give you, to the extent that you're successful, does give you the exclusive right to that phrase, that title, that business name, that particular logo in your business. So, and that process, once you start it, it's a little bit, copyrights you can do on your own. You can file those, you can pay that minimal filing fee. Like a lot of those can be handled directly. Welcome to Sarah and welcome to John, who I know popped in. You guys are welcome to say hello in the chat if you've got a question. We're just talking right now about trademarks and copyrights. And I apologize, I'm on the phone today. My Zoom locked me out on my computer and never sent me the verification link that it's supposed to let me get back in. So with trademarks, once you file, copyrights generally are going to take you about 8 to 10 months to get a copyright registration. Trademarks are more like 12 months to 18 months. This largely depends on the examiner that you get assigned, how many applications overall the trademark office is dealing with at the time. Like there's a variety of factors, but it's a little bit longer of a process. And, I walk my clients through that process. Sometimes we have to respond to office actions or respond to requests for additional information or whatever. So it's a little bit more involved. But at the end, if you're successful in having a registration, right, you can, this is where people can change from putting the TM after a phrase to the R in a circle, right? That's the registration symbol that says, I have registered this mark. It's mine. I get to use it in commerce. So that's a kind of a quick overview of the process. But just to answer your question about whether you should, if you feel overly attached to it, like you would be upset if somebody else used it, especially in regards to a podcast or disseminating information digitally, because some people, they won't necessarily have a podcast hosted on third-party platforms, but they might start a video show or they might start a show hosted on YouTube, right? That kind of falls in the same space. Would you be devastated if you were precluded from using that? So, yeah.
So I have a question. If let's say you have content, like you have content that is older and someone else, can someone that's not copyrighted, formally, and someone steals your content, since let's say they are using some maybe a trademark that is referencing something from your content, and they actually steal pieces of your content or whatever directly, can they claim that as theirs now because you didn't do the filing for that copyright within that 3 to 6 months because it's several years old and someone is using that now in their trademark? Is that something that's possible, or people do that?
It is possible. Yeah. To answer your question, people do take, information all the time and claim that it's theirs. The reality is that with any information that you publish online, there can be ways to show when you published it, right? So if you do get into a battle of like who owns it, and the reality is some people are still successful with, let's say they have to do a takedown notice or, hey, you're infringing my content. One, you want to have a really strong basis for determining that. So for example, I've seen plenty of times in the online space where somebody will call me up or we'll get in a consultation and they'll say, I think so-and-so took my content, or like my client recently who was on the receiving end of such a demand, like, you need to take down your logo. You clearly have copied mine. He's like, no, I didn't. I hired a branding company. We're not aware of you. They were not aware of you. Like, people can create logos, ideas, even phrases, like virtually simultaneously in the world, even without connection. It's just the way that ideas evolve. And it is why a first to market, first in line, which is what the USPTO looks at, first use in commerce. It's best to be first in line. It's best to have an application underway, because if you do get into a fight, you're generally trying to prove who created it and was using it first, and whether or not there was actual infringement or people just had two very similar ideas. And so what that might look like, let's pretend that you're a course creator, or you have a program that some of your clients have gone through, and one of your clients turns around and ends up using a phrase or content inside of their business. Much easier to draw some lines to like where the overlap occurred, where they were exposed to your content, etc. Much harder if it's somebody on the other side of the world that really hasn't interacted with your content or is not a part of your community or whatever, and you're just trying to allege that they took your content, right? And part of it with copyright, you'd actually be looking at the very specific language. Copyright is a little bit different than trademarks, because trademarks are short, a phrase, a word, a logo, right? Those things can evolve independently. Now, copyright, if you have, 1,200 pages, 1,200 words on a page, and somebody has 95% of those words on their page, much easier to draw a parallel and say they obviously copied your content. And there is a service, by the way, for anybody that's like, oh, that sounds great. I'd like to know if somebody's taken my content and what percentage. Go to Copyscape. Let me just pull it up. Copyscape, I think it's a .net. It's a plagiarism checker. No, it's .com. So copyscape.com. That's what I use to track people who have stolen my content or some of my clients' content. It's really inexpensive, like $15 every 3 months. And they will, I think they even have a cheaper version, but they'll scan like up to, depending on your level of subscription, I think I'm like at 10 pages of my website that they'll scan on a, I want to say, semi-monthly basis, like twice a month. And then they'll send me results. Here's the hits that we found of somebody who took your content. And so that's an easy way. If you know you're getting a lot of exposure, you know that eyeballs are on your site and you're concerned about it, put a service like Copyscape in place, because it will tell you, here's a match and this is the percentage match that it is. And so when you've got somebody even above 60%, 60, 70, 80, 90% of a page, they've just taken your stuff, copy and pasted it, and then plugged in a bit of their own information or done a few tweaks. And that's an easy way to do a double check.
So if you have a business and it's trademarked, and then you have all the content underneath it do you still have to officially get all that content copyrighted to protect it, or does it stay under the umbrella of your business?
Trademark, they're each in their own lane. Trademark protects a word, a phrase, or a logo. That's it. Copyrights protect the body of the work, the content that you're creating, the articles, the videos, they do not overlap. So just because you have a trademark doesn't mean anything else is protected. It means that particular mark is protected.
Wow, that's a lot of really having to back up everything that you have, it sounds like.
Yeah, you just have to really understand what intellectual property is essential to your business. What
Mhm.
phrases or taglines are you using? What would be so devastating to your brand if you could not use it any longer, or if other people were using it in the marketplace? And if the answer to that question is like, yes, it would be devastating, or yes, it would be terribly problematic if I had to give up this phrase or not use it anymore, you need to be looking into trademarks. Now with copyrights, right, understand that a copyright registration does not protect the idea. A lot of people have similar ideas.
Right.
It protects the unique expression of that
Mhm.
idea,
Right.
right?
Mhm.
So it's really about how do you express it.
Okay.
All right.
Okay, great. Thank you.
Yeah, I know. There's a little primer for everybody on copyrights and trademarks. What other great questions, Yasmin? What other questions do we have today, folks?
I have a question.
Yeah,
Can you hear me?
is this John?
Nolan.
Nolan. Hi, Nolan. Good to have you today.
Hi. Yeah, thanks. And thanks for going through the changes you had to go through to be here. We appreciate it.
Yeah, you're welcome.
Hey, so being that we're talking about trademarks and copyrights, I've got the perfect question.
Mhm.
We have an image that we use on our site, on one of our sites, and it's a shot that I took of some bags to show that we do deliveries,
Mhm.
and somebody was using it. So the proper thing to do, excuse me, should we send a cease and desist letter, or is it something we need to sue them? It's kind of like, we don't want to make a big deal about it. One of my business partners says, yeah, let's make a big deal about it, but it's not a big deal.
Yeah.
And then the same thing happened on the opposite side of the coin. We have volunteers help us with our websites.
Mhm.
And one of our websites, a volunteer used an image that was supposedly owned by Reuters.
Mhm.
But again, it's just a real simple image of bags. And so that's why we replaced it. And immediately after we replaced it, someone used our image. But we're not too worried about that. But
Yeah.
when Reuters uses a service you called copyscape.com. Reuters
Mhm.
uses a service that's similar to that, but what they do is they work on the premise that we'll find images of yours that are used by other people, and then we give you a percentage of what we collect. So it's kind of like it's a very interesting, and these companies have they've been around for a while. And I know because one of my businesses is I'm a photographer and I shoot a lot of celebrities.
Mhm.
So I've had hit up by these people all the time, like, hey, use our service. We won't charge you until we collect money.
Mhm.
So we've got sort of these two-way street going here, and we're just trying to figure out, again, we don't want to make a big deal about it, but
Yeah.
on the other hand, this company wants to sue us, is making a big deal about it, because
Yeah.
if they don't collect money, then they don't make any money from Reuters.
Mhm. Yeah. So first of all, you're experiencing something that is super common, which is that people bring somebody in to work on their website, their marketing. That person is inexperienced and not particularly well managed, and they do something
Okay.
like this. That's a big no-no. So there is liability for that, particularly if the image is protected by copyright. If there's a registration associated with it, you can be on the hook for damages. That said, they still need to show damages, and and vice versa on your image. The first question I would ask is, did you have a copyright registration? If yes, then yes, you could pursue them legally from the standpoint of bringing a lawsuit. If no, you're kind of left to negotiate with them and hope that they just do the right thing and either pay you a little bit or at least take it down, right?
Right. And they've already taken it down because we contacted them.
Oh,
And
got it.
I
Okay, because you were
apologize.
asking me, yeah, you were asking whether you need to send a cease and desist. It sounds like you already did.
Yeah, and we just talked to them. Well, they haven't. I hadn't gone on there this morning, but as of Friday, they promised to take it down. So I'm
Yeah.
assuming they will.
Yeah. Well, and you could always put a copyright notice right on the image. This is the other thing for photographers that's super important is you can put like
Right on the image. Yeah.
Yep, a watermark or copyright notice right on the image. Because if somebody takes an image and scrapes that off, you can get access to some additional penalties that you wouldn't otherwise have access to. You would just need to connect with an attorney who does enforcement actions, right? And
do you do that?
I don't generally. I will help with a lot of my clients in getting content removed, but I don't bring lawsuits on. Like I don't litigate in, in IP, just because litigation is such a time sink, and I really spend most of my time proactively helping folks build out protections in their business. But I could collect a referral if you're looking for somebody to handle it. Where are you based, Nolan? Are you
California?
California. I was thinking California because I feel like we connected before.
Yeah.
I could help get a referral for you if you're interested. So
I would be.
Okay. Yeah.
Excuse me.
So let me reach out to my listserv, and then if you'll just email me, just drop me an email to heather@legalwebsitewarrior.com and just say, hey, Heather, this is a reminder. It's Nolan. Please send me the referral when you get a chance. Then I'll reply to that and we'll get you,
Okay.
hopefully get you some names.
And on a lighter note, I also am part of a nonprofit, and in that nonprofit, we have lots of volunteers. And one of those volunteers is a graphics person. And the graphics person created a poster for us. We produce a show called the Cammy Awards, which is the area in California where we are. It's like the Grammys. And and she just flat out went to the Grammy site, grabbed their image and turned it into a poster for us. So at our meeting, we're like, nope, stop, you can't use this. And I was the one that brought it up, and I'm not even a big fan of the Grammys. Anyway, believe it or not, we got sued by the Grammys.
Oh my
and I'm
God.
laughing because it all worked out. They wrote a cease and desist, but we're this tiny little, we're in Calaveras County. If you look it up, it's a tiny, it's one of the poorest counties in the entire country.
Wow.
And for this gigantic organization like the Grammys to sue us, we all kind of thought it was funny. But their law team really just was very good about it and gave us time, and we didn't have to bring in an attorney. It all worked out great. But it was funny. How many people can say they got sued by the Grammys?
Well, I'm glad you can say that and laugh about it. What you have experienced is actually an obligation faced by a business once they have a brand name or they've created a name for themselves, they're creating content. Because what happens if you don't enforce that stuff? You can lose your IP rights, right?
I read that.
Yeah, this is the thing a lot of people don't understand is they think like, oh, all these people are just big jerks, like give it a rest. And it's like, no. This is the thing about IP is that you, if you have taken the steps to protect it, you can't just let people use it willy-nilly because you can lose it. So yeah, interesting. That's a really interesting highlight.
What was really funny was that it started out as the image. We immediately removed the image, but we didn't even know she had put it up where she put it up at. So we immediately removed it. And then they went after us for the name, which was Cammy's, and which when we did our research, we found a bunch of Cammys all over the country, but we didn't make a big deal about it. We just said, sure, we'll call it something else. They made a suggestion and we actually used their suggestion just to make them feel good. Anyway, quite an experience to say the least.
It sounds like it. Well, thank you for sharing.
Yeah, thank you.
Yeah, good to have you. All right, who else has questions today? Feel free to pop it into the chat or just go live. Anybody else? Welcome to Sarah. I see that John is still on, and Glenn. Anybody with a burning question or something related? Hi, Katya.
Hi. Yeah, I have a question about trusts, both for me personally, with my kids downline with property, but I'm writing a book about a history book about the Statue of Freedom on the Capitol Dome, and we're putting out a lot of content, and maybe we'll do multiple books. So I wonder if we should create a trust, like the Lady Freedom Trust or something like that. And I don't even know really what a trust does. So
yeah, so trusts are typically used in estate planning, right? So trust can be a way to house certain assets, and depending on the type of trust, right? There's revocable trust, there's irrevocable trust, there's a variety of different kinds of trusts that you can house assets within. Now, a lot of people, unless you've truly set up an irrevocable trust, which means you've placed certain assets within the trust, you have no access to them. Because a lot of people, the reason they use trust is to try to use it as an asset protection mechanism, right? Or an estate planning tool. So for example, a lot of folks with young children will have, a pour over trust or a living trust where if they pass away, their assets will automatically be placed in trust and disseminated that way, put in, somebody else would come in, be the trustee, and use those assets to help provide for the children or whoever
I
else.
have one of those. Yeah, I
Right.
have one of those for 2 kids. Yeah.
Yeah. In the business context, typically what you see when you're talking about protecting IP, protecting assets is actually setting up business entities as one of the mechanisms. So for example, for certain of my clients that create a whole ton of IP, they might actually have an IP holding company, right? So it's usually a separate company that is set up specifically to manage their IP. And this is particularly helpful for clients that have a lot of IP. They've got, more than one trademark. They've got a bunch of copyrights. They literally need, a place for all of these assets to be housed and managed and controlled. And then what happens is they're usually licensing that IP to one of their operating companies. And that way the asset does not live inside of the operating company that is creating the risk. So for example, let's talk about somebody with like a consulting business, right? So they have an operating company, they're doing their consulting out of that business, but maybe they publish a ton of information, articles, books, resources, all of the assets that you can think of, podcasts, whatever. And they want the IP to be housed somewhere else, because if their operating company were to be sued, they don't want somebody in the context of a lawsuit being able to just grab up all that IP because it's valuable, right? So there can be strategies in the context of business about how you structure and house your IP so that you provide the most protection, both for the IP itself, but also, separating out that liability from the operating side of your business. So, that would be my recommendation. The trust, if you were using a trust.
What do you
Oh,
call
go ahead.
that? What do you call that? A certain type of trust? Oh, that's the
no,
living.
it's not a trust. It's an IP holding company. Yeah.
Oh, okay.
Yeah. So for a lot of my clients, that looks like an LLC, right? It looks like a secondary company to the primary one they've already set up, where they transfer and house their assets inside of that company.
Okay.
So now the question that I would ask is, are you bringing in risk into your business such that it necessitates the additional expense to undertake a strategy like that, right? For a lot of folks, the risk level may not be that high, depending on their work, depending on what they're doing. For certain folks with a ton of exposure, or they consult with companies that are paying them a lot of money, which means the risk is higher, then yes, that strategy may make sense. You may need to get really serious about how you protect and house your IP, just because there's more risk inherent in the work that you're doing. So I always try to do a risk reward trade-off and look at that balance of, is there substantial enough risk to necessitate this additional investment into your business by way of other legal supports or other legal strategies to help contain that risk.
So like with my book and possible other books and podcasts and all of that, that's a different type of trust, I think. So what?
Well, I'm not sure why you would be housing those in a trust, I guess is what I'm asking. Did you get some advice somewhere along the way that you should put them in a trust?
Yes, someone wants me to put them in a trust. She doesn't know that much about legal stuff, though.
Yeah, I would not take advice from people that do not know that much about legal stuff. Yeah, so I'd probably just, and Katya, where are you based?
Northern California.
Northern California. So what I would look at, so typically folks who are building businesses and have some estate planning to do, you'd have a business attorney and you'd have an estate planning attorney, right? Usually separate functions. Some legal offices will do that out of the same office, but they are two different things, two different areas of law that you would want to look at. The estate planning definitely can impact your long-term business strategy, especially succession planning. So for people that have built a business and are looking at like, okay, what am I going to do with my business or my business assets or anything else when I'm winding down business or when I pass away? You want to understand how your business strategy, including your succession planning, overlaps or impacts your estate planning, right? So they can be related, but they are distinct areas of law.
Yeah, that's what I'm trying to figure out.
Yeah. So typically, if you're talking about protecting IP, right, the ways that you would protect books are with copyrights, right? Getting copyright registrations. And if you're creating a book series, you can get a trademark registration on the series name or the series title, not on individual books. So you cannot obtain trademark protection for a single book title. You can, though, of like the Harry Potter series or whatever, you can get trademark protection over the series title, right? The series itself, but not individual books.
So it sounds like I should be looking into trademarks. Of course, copyright too.
Copyright too. Yeah. And depending if you're self-publishing, right, then you would submit your own book to the Copyright Office within 3 months of completion to make sure that you are covered with a formal copyright registration. If you're going through a traditional publisher, they will often handle that for you. It is usually built into the publishing agreement that they will submit it to copyright, to federal copyright on your behalf. So you just want to make sure that one way or the other you're covered. And then with the book title, again, if it's a series and you're interested in protecting the title of the series, yes, you could look at trademark protection for the series, but not for an individual book.
Okay, wow. That's really helpful. I'm glad we talked about copyright and trademark first.
Yeah, it's a big topic. It touches so much of what we do in business. So there's a lot of questions under that umbrella. But yeah, for the estate planning stuff, I would connect directly with an estate planning lawyer who understands your scenario, looks at both, the personal and business side, and then could help you with your strategy there.
And are you that or not?
I don't do estate planning. No, I only do business law.
Okay.
Yep.
So for business or trademark, do I go with you or I just?
Yeah, so trademark, I handle trademarks for my clients. I can help coach them on copyrights. And then I do a ton of business contracts, coaching and guidance around business entity formation, dispute resolution, overall IP strategy. It's basically like everything that touches my clients' businesses within the context of business law, I can support them with. If it's location based, because like I will work with clients around the US and the world, if it's location specific. So for example, if I've got an East Coast client and they're facing an employment law issue, we will need to get them connected to local employment law counsel because that's state specific. So there are certain things that I can provide kind of preliminary guidance on, but not go very deep into because they will need local specific guidance.
Right. And what the book is a national story. So I could do that with you.
Yeah. Yep.
Okay, great.
Yeah.
Thanks.
Good to connect with you, Katya. Thanks for your
Yeah.
questions.
Good to be here.
Good. Anybody else today? We've got, looks like a few minutes left. So you're welcome to go live. Oh, hi, there we go.
Hi, thank you. I have a question. I have a professional license in New York State, and I have that like all set. That's a business, a whole business on its own. But I'm wanting to do a separate business that's kind of like adjacent to that, but it can't involve my license at all. Like,
so you must be licensed, I'm assuming, like in the healthcare space or.
yes, mental health. And then I'm wanting to do like online courses. So I'm gonna set up an LLC for that, totally separate. My question is around, can I market the LLC business on my webpage for my private practice business?
Good question.
Like, like if I even just had a link to go over, I know I can't use like obviously any client content or I can't really mix them and I don't want to at all, but I have probably I have an ability to generate a lot of activity to build this new business from even people who might not be my clients, but who might, know of me or have heard of me. So I want to use my name as a way to get people over to that other business, but I can't be having it affect my license at all.
Totally.
So I've seen people do that where they'll either just have a tiny link or they'll have a whole tab, but I wasn't sure how I can figure out whether that's actually wise legally.
Yeah, that's a great question. And so anybody else who's on the call that comes from a licensed profession or that sees this recording, first of all, kudos to you for understanding that they really do need to be separate businesses. What a lot of people will do is they will, like if they're in the therapy world or the medical world or whatever, they'll call their insurance provider, their medical malpractice provider and say, hey, can I do coaching under the umbrella of, this insurance? And the insurance company often will say yes. The risk of that though is that typically under your license, right? So whatever license profession you fall under, you're going to have limitations on that license that are prescribed by state regulations, state law, right? You're going to have a local regulatory body that oversees that licensed profession. And so what I always tell people is start by understanding whether it's rules of professional conduct, your local license regulations, start there. There's going to be a set of codes somewhere, set of legal code that you probably should go read. It's going to talk about any restrictions on marketing, any restrictions on referrals, any restrictions on whether you can pay people for affiliate or referral income, like all sorts of things, right? And if you've got questions, if you're able to find that and take a look at it and you still have questions, then I always recommend that for licensed professionals, you do need to connect with an attorney in your state who helps licensed professionals in that state to be able to understand what are the rules of that license. Now, when I'm working with licensed professionals, and I've done a lot of work with a very wide variety of licensed professionals, I always recommend, one, starting with understanding the rules of your licensed profession, but two, setting up a second business. And let's be clear that I always reference those businesses as an online education and information business, right? So that So even when you're going to pursue, let's say, insurance, business insurance for that second business, or a description at the state level of registration, right? It's an online information and education business, very separate and distinct from your primary therapy practice or whatever else, people are doing as a licensed professional. And it means you set them up separately. They're housed under a separate legal entity, like you set up an LLC, right? And they should, in all other ways, be treated as separate business banking accounts, not commingling funds, making sure that if you are putting a new client service in place in business number 2, you've got an agreement specific to that business. A lot of people end up mixing things, and also the functions in your business need to be different, meaning that as a therapist, you cannot be providing therapy in business number 2 and just calling it coaching, right? Mm-hmm. The functions need to look very different, because the question you want to ask yourself in regards to any business activity that you undertake in either business 1 or business number 2 is this defensible? If I ended up in front of my local regulatory agency or licensing review board, could I defend this particular business activity or action and explain how it's separate and distinct, show how carefully and precisely I've separated out these businesses, so that what I do over here in my online information and education business is very, very different than what I do over here in my my licensed therapy practice.
Okay, thank you so much.
Yeah, absolutely. And then in regards to your specific question around, can you link? Because I think what I'm hearing you say is like, look, you may have a lot of people that visit your primary website that could really benefit from joining you over in an online course or your group program or whatever, right? And so I would say that, first double check whether or not there's any marketing rules that apply based on what you can find out about your local license regulations. But 2, be very careful with the language, right? If you're looking for courses or resources on these topics, like depending on where you mention it, you might be able to do like a blog post or a link at the bottom that says, I also run, and then the name of your second company, right? Where I provide online information and education, or something that shows it's distinct, but it is an additional resource, right? And then on that website, you want to make sure that you have a disclaimer in place that's very apparent that says, look, while I am a licensed therapist, the information and education and services offered through this site are not therapy, right? Yeah. Here's what they are. Like, you want to just be really, really clear. What are people getting through each business at each location? And you do that through your language on your website, right? Your marketing, your enrollment process, and your client engagement agreements, right? Your client service agreement. So there's multiple ways that you can create a very informed client in both businesses.
Okay, yeah. Thank you so much.
Yeah, you're welcome. Great question. All right. Anybody else? Just scrolling to see if we have any other live faces. Feel free to go live or just pop a question in the chat.
I have another quick question.
Yeah.
You talked earlier about a revocable trust and an irrevocable trust. Mm-hmm. What is the difference between the two?
Yeah, so a revocable trust. Go ahead.
I was just going to say, you don't have to go into super details because I know what trusts are, but yeah, just trying to see what's the best for the two.
So the quick overview is that a revocable trust says, I'm going to put a trustee in place of all of these assets, and it's revocable. I can remove the trustee. I can change the plan for the trust. You still have management or control. And that's really the issue when it comes to asset protection. What any creditor is after is the assets over which you have control. And so with a revocable trust, you still maintain management and control of that trust. Even if you put a trustee in place, you're able to revoke that position. You're able to change it. With an irrevocable trust, this is a safer way, although it's still not entirely a bulletproof way to do asset protection. But an irrevocable trust means you put a trustee in place and you put some rules in place that make that irrevocable. You can't change it. You can't withdraw it. You literally no longer have control. The trustee is left doing their job in accordance with the rules of that trust. So that becomes an irrevocable trust. And
that almost seems irrelevant. It almost seems like, why would somebody use an irrevocable trust over a revocable trust?
Well, they do it for asset protection. That is why people do it. Like, look, if I set the trust up, I put the rules in place about how I want the trust to be administered, and I put another trustee in place, you're left really like a trustee's name, right? Trustee, like you have to trust that that person will execute their job. And this is why they're professional trustees, right? You can hire companies to act as trustees over a trust, and they
wouldn't both of those protect your assets?
No, a revocable trust does not provide any asset protection. You still have control over the assets, which means a third party creditor coming after you can come directly after the trust.
Oh, really?
Mm-hmm.
Because you can change it.
You can change it. You can reach in and withdraw assets. You can do any of the things, right? And so you still have, yeah.
I see. So in other words, as far as the irrevocable trust goes, you no longer have control over it. You can't reach in and meddle in the pot and withdraw funds and mess things around and have control over the assets. You don't. So it makes it a safer mechanism if you are going to do an asset protection strategy, but there are certain states where it's still not totally bulletproof. And if you are putting a business within a trust as one of your assets, you can still make changes in the business and operate the business as you see fit.
Right. Generally
so that
speaking,
doesn't change.
Yes, that's correct. And you know, again, you'd want to like wherever you are, you Nolan being in California, but anybody else who listens to this call, estate planning is also heavily influenced by state law, right? Certain states have probate and probate's fine. Certain states have probate and it's terribly problematic. So you want to trust. So you really have to have somebody that understands the estate planning rules where you live, because your strategy might be different strictly based on state location, right? So just make sure that wherever you are, there is no one size fits all when it comes to estate planning. You want to understand, what are the rules that apply to you, not only in your state, but based on your level of assets. Somebody who has minimal assets may not be a big deal to go through probate, right? Somebody who's got multiple millions of dollars doesn't want to have their stuff all tied up in probate. So it's, understanding, what level you're at and truthfully what laws are going to best support you in your estate planning is best done with a local state specific attorney.
Got it. Thanks.
Yeah, good question. All right. Anybody else? All righty. Going once, going twice. Let me make sure that although I need to go up here, I need to figure out how to pull up the chat. Here we go. Anything else in chat that I missed? Maybe somebody can tell me, since I seem to not be able to find it that easily. Here we go. There's chat. I have to pull up the settings. Let's see. John says, the way the law is written, that your work is automatically protected without filing anything. Okay, we were talking about copyrights then, and I'm sorry, I'm just seeing this now, John. However, without formally filing a copyright registration, your damages are limited by statute. Yes, you can sue for additional damages. That's correct. And if you have a federal registration, you can recover attorney's fees. This is the cost prohibitive thing that keeps most people away from court pursuing infringement scenarios, is if they have to pay attorneys, it becomes cost exorbitant. if you have a federal level registration, you can recover attorney's fees, which actually makes it possible for people to pursue their rights. Okay, let me look what else. Okay, Nolan, there's also a way to have Google shut down the violating site if they fail to take it down. Okay, yeah, that's when we were talking about that issue involving somebody taking your photo. So the other thing you can do with copyright violations is if somebody, and I've had this happen actually several times, where somebody just refuses to take something down, you can actually also issue a takedown notice to the hosting company of the website. So third-party hosting companies, there's a safe harbor provision under the DMCA, the Digital Millennium Copyright Act. And what it allows is that third-party companies who host other people's content, if they respond to a takedown notice by removing the content, they're in the safe harbor. They are no longer at risk of being on the hook for any ongoing violation through that particular infringement scenario. Now, the person whose website it is can put the content back up, right? And then the website host has done their part. They don't have to do anything else, but you would then have to pursue the direct infringer. But as a first step, if you have a non-responsive party, sometimes if you really analyze the scenario thoughtfully, because you don't want to do this just willy-nilly, especially if you're not positive that the content is yours, you can actually be on the hook for like business damages if you take down somebody else's content alleging that it was yours and it's not. And this is particularly important. So for example, as a recent example, I had a connection and I was just on a connection call with him. He's a colleague. We've talked several times. And he said to me, hey, this guy's infringing my trademark. And I said, well, let's look it up real quick. And so I went to the alleged infringer's site only to discover, like, no, he's not actually infringing your trademark. And this guy had already issued like an initial notice to him and like started the conversation. And I had to explain to him how it wasn't actually infringement, right? So trademarks, you get a prescribed use in a certain class related to how you're using that phrase or mark or word in your business. Doesn't necessarily mean that nobody else in the world can use that particular word or phrase, especially if it's a phrase that people use like in the normal course of language, right? So people frequently misunderstand their intellectual property rights, which is why I just always say, if you have access to an attorney, even somebody like me that provides free calls, like take advantage of it, because you don't want to misstep. You don't want to issue a cease and desist. You don't want to issue a takedown notice to a third-party host without really understanding the issues involved and the rights, because you can then be on the receiving end of an action pursuing damages against you. So just my quick pointer for the day. All right, any other questions? I don't think I saw anything else in the chat. I'll go check one final, maybe I'll check, how do I get to it? Oh yeah, the dots, okay. One final chance, going. I don't think I missed anything else.
Quick, just real quick. When we were talking about the damages earlier, you said that, is there a copyright infringement, and that I would have to find out if it was copywritten.
Oh, if there was a copyright registration, yeah.
Yeah, and then registration for you said a registration for damages. So, and what are the damages? So how do I figure out what this?
So my question is, was there a copyright registration on that image?
On the image, right?
Yeah, and typically if they have legal counsel reaching out to you, if there's a copyright registration, legal counsel is going to say, hey, this image is protected by copyright registration number, right? And indicate the number. Right. If not, they're just going to allege general copyright infringement. So, and if that's the case, if they don't have a registration, then they need to prove damages, right? They need to show actual damages, which can be a challenging thing to do depending on the length of the use, where it was used, you know, how far your your reach is, how, you know what I mean? How many people purchased through your site while you had that image live? Like it can be a tricky thing to get to the bottom of, but
Right.
people do need to be responsive to those demands. If they have infringed somebody else, they do need to be responsive.
Yeah, and then we reached out to the volunteer that actually put that up, and we haven't talked to them yet, but hopefully I'll talk to them today or tomorrow and find out.
Yeah, and the only way that liability, let's be clear, the only way liability transfers to, let's call it an independent contractor or an employee, you've got the liability, right? And in most circumstances, the company, the liability is going to rest with the company or the organization, because
Sure.
right, with an independent contractor, you'd have to have a specific clause in place that says they're responsible for that particular content creation or for using work that only they create, right? And not infringing third-party rights. And in my experience, a ton of businesses work with volunteers, or it doesn't matter, whoever, not very well paid independent contractors or whatever, and they don't have their bases covered on their various agreements. So, you know, informing her is one thing, passing on liability to her is quite something else that you're probably pretty unlikely to be able to do.
Right. Okay. Thanks again.
Yeah, no, absolutely. It's just why, you know, for me, and I'll just put my little plug here about where legal fits in my mind for most small businesses, in the leadership category. People are better leaders of their business when they understand some of the, you know, basic legal principles and nuance of law that apply to them. It really just allows you to lead your business more responsibly and more successfully. And so, you know, my joke is that I deliver leadership, but through legal support.
Got it. And you're right. Absolutely. Thanks.
Yeah, you're welcome. Good luck with that. All right. Any other questions? We've covered quite a bit today, especially in copyrights and trademarks. Anything else before we sign off? All right. Well, good to see you all today. Thanks for sticking through the technology issues. Next week, I'll be sure to have this sorted, or not next week, next month. Be sure to have it sorted out, but hopefully you can join me on the next Ask Me Anything Live. The rest of the year, they're all on the second Monday of the month. You're welcome, Yasmin. Great to see you today. All right, folks, good to see you all. Take good care. Nice.
Thank you so much.
You're welcome. Yes, so great to see you as well, Katya. And reach out and join the next Ask Me Anything Live if you've got any additional questions.
Do you have a class on trust or something like
not
that?
on trust, because I don't do estate planning. Well, I know some things about trust.
No, I meant trademarks.
Trademarked. Yes, so I don't have a class on it. I offer it as a service, and then, you know, through my Ask Me Anything Lives, I also have a legal basics boot camp, right, which is just a free kind of mini series type of training. That's generally where people start to get their, you know, their groundwork in place for understanding what their legal needs are. So but if you want, Katya, I've got an FA
boot camp, legal boot camp, you said?
Legal Basics Boot Camp. Yeah, you can go find it on my website. If you just go to legalwebsitewarrior.com, it's the very top bar you can opt into. But Katya, you can also go, I have an FAQs page for trademark. So if you go under resources and more, just go to the trademark link, because it's a trademark Q&A, and you can just click on that. And I have a whole bunch of questions that I get asked about trademarks on that page, and you can click on them and see the answers. And then if there are other questions, just show up to another Ask Me Anything Live or reach out to me.
Thank you so much.
Yeah, you're welcome. Okay, everybody take care. Have a great week. We'll talk to you soon. Bye-bye.
Bye-bye. Bye-bye.